Dearly beloveds, 4 days after the trial ended and 1 day before he died, William Jennings Bryan had a conversation with his wife, Mary. She recounted that conversation in a portion of his memoir that she wrote after his death. Let's go to slide 2. The memoir says, Mr. Bryan and I spoke of his work thus far, his effort to prove the presence both in the church and school of a theory which, when taught as fact, tended to destroy belief in the truth of the Bible. That having proved the existence of such a situation, he was trying to do 3 things. First, to establish the right of taxpayers to control what is taught in their schools. Second, to draw a line between the teaching of evolution as a fact and teaching it as a theory. And third, to see that teachers proven guilty of this offense should be given an opportunity to resign. Let's go to the next slide. We spoke of the narrow margin between this perfectly legitimate work as touching the public servant and an encroachment on the individual religious belief, which is a sacred domain. We agreed that care must be taken at this point that no religious zeal should invade this sacred domain and become intolerance. Mr. Bryan said, "Well, Mama, I have not made that mistake yet, have I?" And I replied, "You are all right so far, but will you be able to keep to this narrow path?" With a happy smile, he said, "I think I can." "But," said I, "can you control your followers?" And more gravely, he said, "I think I can." And I knew he was adding mentally, "by the help of God." Good morning. Today, I want to offer my own very personal view of the legacy of the Scopes trial. I have left more than the usual amount of time for Q&A on the back end. I want to encourage those of you who are on Zoom to use the chat function, because I want to hear some discussion among all of us, to hear your points of view on what you've heard throughout the course and what you're going to hear today. I'm going to talk about the trial's legal legacy, but I will cast a wider net to talk about its legacy politically and socially. I will draw upon my 3-day visit to Dayton, Tennessee in late March. And before I conclude, I'll offer my response to the conversation between William Jennings Bryan and his wife, Mary. So what is the legal legacy of the trial? This could be a course all by itself. I'm going to talk about a bunch of cases quickly. I will do an injustice to all of them in treating them the way that I will, but I want to give you a brief overview. Let's go to the next slide. In 1928, Arkansas passed a law prohibiting the teaching of evolution. In 1968, that statute was tested in the Supreme Court in a case known as Epperson versus Arkansas. For the intervening 40 years, the law was not enforced. But a man named Forrest Roselle wanted to get the Arkansas law repealed. He was the executive secretary of the Arkansas Education Association. He couldn't get it repealed, so he set out to challenge the law in court, and he found a woman named Susan Epperson. Susan Epperson's father was a science professor at the College of the Ozarks. She had gotten a master's in zoology, and she was a Christian who saw no conflict between her Presbyterian faith and Darwin. In 1965, she was a teacher at Little Rock Central High School. That's the school that gave us the Little Rock Nine in 1957, those students who were able to attend this previously racially segregated school only after the intervention of President Eisenhower. Susan Epperson was 24 years old, the same age as you-know-who at his trial. The difference is that Epperson actually was a biology teacher, and she actually taught evolution. So she became the plaintiff in a lawsuit that was backed by the Arkansas Education Association and the ACLU with the help of the Little Rock Ministerial Association, and she had a co-plaintiff who was a parent with children in the school. The U.S. Supreme Court heard the case on October 16, 1968. Epperson's lawyer told the Supreme Court that Mrs. Epperson had testified in the trial court that she did not wish to teach that the theory of evolution was true, but simply to explain it because it was contained in a chapter in the biology book that had been furnished to her by the local school district. This is an interesting argument. Not that the theory of evolution is true, just to tell you about it, that's a rather tepid stance, to be sure. Now, when the lawyer for the state began his argument, he first said to the justices that the case had originated in 1965 prior to the administration of the present Attorney General. The present administration took over the defense of this lawsuit after it was decided by the Supreme Court of Arkansas and appealed to this court. Why would a lawyer say that? There's only one reason, and you don't need to be a Supreme Court justice to figure it out. Without missing a beat, Justice William Brennan asked, what was the significance of that statement? And the lawyer for the state of Arkansas, a Mr. Langston, replied, just background, Your Honor. Justice Brennan, I just thought you were telling us that your administration doesn't like this law either. Mr. Langston, no, Your Honor, I'm not prepared to say that. Justice Fortas, it might not be too late, you know. Transcript, laughter. In the Supreme Court courtroom, laughter. Mr. Langston continues for the state of Arkansas. To be consistent with my argument, I would have to say that I, of course, think that the state, in prescribing the courses in the schools, could say what theories can and cannot be taught there. Justice Brennan, on that theory, would you think that the state could make it illegal to mention or teach geometry? Mr. Langston, there would have to be a line drawn here somewhere. Laughter. Chief Justice Warren, that's our problem too. I listen to a lot of Supreme Court arguments. A lot of time is spent in the arguments with justices saying, where do we draw the line? If I accept your argument, where does it lead? Mr. Langston says to Chief Justice Warren, I'm glad that's your problem. More laughs. Now, you could say that the justices belittled Mr. Langston's argument, but Mr. Langston practically joined right in belittling his own argument. 27 days later, by Supreme Court standards, the speed of light, the court ruled unanimously that the Arkansas statute was unconstitutional. Justice Fortas wrote the majority opinion of the court. The First Amendment does not permit the state to require that teaching and learning must be tailored to the principles or prohibitions of any religious sect or dogma. No suggestion has been made that Arkansas's law may be justified by considerations of state policy other than the religious views of some of its citizens. It is clear that fundamentalist sectarian conviction was and is the law's reason for existence. Next slide, please. The next year, a mutual friend arranged for Susan Epperson to have lunch with John Scopes. The Epperson case was the end of state efforts to ban the teaching of evolution outright. Next slide, please. So in 1981, Louisiana passed the so-called balanced treatment law. The balanced treatment law was, you can teach evolution, but only if you also teach creationism. So in 1987, the Supreme Court heard the case of Edwards versus Aguillard challenging that law. And by a vote of 7-2, the Supreme Court held that the law was unconstitutional. The 7 in the majority said that it impermissibly endorsed religion to advance the religious belief that a supernatural being created humankind. I want to spend some time on this decision, partially because it's the last time the Supreme Court made any pronouncement about creationism and evolution, and partially because looking at the majority and then looking at the dissent brings the dispute into sharp relief. Justice Brennan wrote the majority decision. He said, Louisiana has identified no clear secular purpose for the law. They say the stated purpose is academic freedom, but Justice Brennan said the act was not designed to further that goal. He says, how do we know? Quote, the goal of providing a more comprehensive science curriculum is not furthered either by outlawing the teaching of evolution or by requiring the teaching of creation science. He said, requiring schools to teach creation science with evolution does not advance academic freedom. He said, there's no current law that prohibits Louisiana teachers from teaching any scientific theory. If it's scientific, you can teach it. Remember that. Brennan goes on more about how we know the purpose behind the law. We need not be blind in this case to the legislature's preeminent religious purpose in enacting this statute. There is a historic and contemporaneous link between the teachings of certain religious denominations and the teaching of evolution. He noted that supporters of the law had relied in part on creation science experts, and they had testified that creation science included belief in a supernatural creator, and that a creator was responsible for the universe and everything in it. So creation science, as contemplated by the Louisiana legislature, embodied a religious belief that a supernatural creator was behind humankind. Justice Brennan says the purpose of the act was to structure the science curriculum to conform to a particular religious viewpoint. If there are those of you who disagree with Justice Brennan, I say this is what you get when Supreme Court justices are appointed by rabid left-wing socialist presidents like Dwight David Eisenhower. Let's stop the share, please. Now we get to the dissent by Justice Scalia, who was joined by Chief Justice Rehnquist. Some of the great back and forths between justices in our lifetime were between Brennan and Scalia. Justice Scalia says, the Louisiana legislature did this with great care. They took an oath to uphold the Constitution. The majority now says that the Louisiana legislature violated their oaths and then lied about it. Justice Scalia says, I dissent. Regarding Louisiana's experts, he said, these experts insist that creation science is a strictly scientific concept that can be presented without religious reference. Justice Scalia says, look, there was no trial, there are no findings of fact by a judge or a jury, so as a procedural matter, we must accept those experts' statements as true. We must assume that the Balanced Treatment Act does not require the presence of religious doctrine. Scalia says, yeah, you cannot have the purpose of advancing religion, but that does not mean that legislators are forbidden to act upon their religious convictions. He said, today's religious activism may give us the Balanced Treatment Act, but yesterday's resulted in the abolition of slavery, and tomorrow's may bring relief for famine victims. That's Justice Scalia. Justice Mishkin. This conflates being religiously motivated to achieve a secular result, like eradicating poverty, with codifying religious doctrine into law, like let's teach creationism in public schools. Back to Justice Scalia. He summarized the testimony of the law's supporters. Then he said, our task is not to judge the debate about teaching the origins of life, but to ascertain what the members of the Louisiana legislature believed. The vast majority of them voted to approve a bill which explicitly stated a secular purpose. What is crucial is not their wisdom in believing that purpose could be achieved by the bill, but rather their sincerity in believing it would be. Justice Scalia went on to say, these experts are credentialed. They reference scientific testimony. They say, quote, the body of scientific evidence supporting creation science is as strong as that supporting evolution, and censoring creation science has harmful effects. Back to Justice Mishkin. Justice Scalia's dissent reflects much of what is wrong with the creationist legal argument. The debate between evolution and creation science is no more a debate than would be a debate between astronomy and astrology. They can credential their experts till the cows come home, but the minute the supernatural is a factor, as it clearly is for them, it is not science. Saying the Supreme Court should not judge the debate about creationism and evolution accepts a false premise. It gives religion an undeserved seat at the science table. There is another case entirely unrelated to creationism and evolution that provides further insight into Justice Scalia. Edwards versus Aguillard was 1987. In 2009, the Supreme Court heard a case called Salazar versus Buono. In this case, it was a challenge to a cross having been erected on land in the federal Mojave National Preserve. Listen to the exchange between Justice Scalia and the ACLU lawyer, a guy named Peter Eliasberg, who was arguing that the presence of a cross on this federal property violated the Establishment Clause. Mr. Eliasberg had commented that the cross did not honor all veterans who had fought for the U.S. in World War I. So in the oral argument in the Supreme Court, Justice Scalia asked, the cross doesn't honor non-Christians who fought in the war? Eliasberg, I believe that's actually correct. Justice Scalia, where does it say that? Mr. Eliasberg, it doesn't say that, but a cross is the predominant symbol of Christianity, and it signifies that Jesus is the Son of God and died to redeem mankind for our sins, and I believe that's why the Jewish war veterans, Justice Scalia, it's erected as a war memorial. I assume it is erected in honor of all of the war dead. The cross is the most common symbol of the resting place of the dead. What would you have them erect? Some conglomerate of a cross, a Star of David, and a Muslim half moon and star? Mr. Eliasberg, the cross is the most common symbol of the resting place of Christians. I have been in Jewish cemeteries. There is never a cross on a tombstone of a Jew. Laughter. So it is the most common symbol to honor Christians. Justice Scalia, I don't think you can leap from that to the conclusion that the only war dead that cross honors are the Christian war dead. I think that's an outrageous conclusion. Mr. Eliasberg. Well, my point here is to say that there is a reason the Jewish war veterans came in and said, we don't feel honored by this cross. This cross cannot honor us because it is a religious symbol of another religion. Me. Arguing that the cross is not a Christian symbol demeans two important groups of people, non-Christians and Christians. Telling the lawyer who argued that the cross is a Christian symbol, that is an outrageous conclusion, that's what's outrageous and insulting both to religious sensibilities and to one's intelligence. If Jerome Lawrence and Robert Lee had Matthew Harrison Brady testify that the cross is a symbol representing all religions, the anti-evolution crowd would have screamed that the playwrights were turning William Jennings Bryan into a cartoon figure as a way of demeaning their position. Only in a world in which the cross is not a Christian symbol can creation science be treated as science. I want to take you quickly through a bunch of court cases below the Supreme Court that involve evolution and creationism. If you are a member of Team Scopes, as I clearly am, there are plenty of good results in these cases. But first, I want to do a quick primer or reminder about two key concepts. The First Amendment to the federal Constitution says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So no establishment of religion. We're not going to have established churches. And we're not going to do things that tend to establish or promote one religion versus another, or even religion as opposed to non-religion. No establishment of religion. The free exercise clause. Government's not going to tell anyone that they can't exercise their religion. How do you know where the establishment of religion ends and the free exercise begins? Anybody? Yeah. Who knows? Who knows? Anyone who tells you, no matter what their feelings are on this issue, anyone who tells you that this is simple is not paying attention and does not know what they're talking about. These two constitutional principles have a built-in tension. Now, the law in this area has addressed that tension for decades. As you'll see in a few minutes, the Supreme Court is managing that tension a lot differently now. Let's go back to slide 6, please. So, may a school prohibit a teacher from teaching creation science? The answer is yes. A federal appellate court said so in 1990. It may do so to ensure that the Establishment Clause is not violated and to ensure that religious beliefs are not injected into the public school curriculum. The teacher had no offsetting free speech right. Let's go on to slide 7. Next, is a school teacher's free exercise of religion violated by requiring the teacher to teach evolution? No, said the Federal Court of Appeals in 1994 in the Pelosa case. The court rejected the teacher's argument that evolutionism was a religion. So by now we've seen that the ban the teaching of evolution, that strategy didn't work, and the balanced treatment approach had also failed. Another strategy. What about requiring teachers to offer a disclaimer? Evolution is just a theory, and this isn't to dissuade students from the biblical concept of creation. No good, said a federal court in 1997 in the Freiler case. In mandating this disclaimer, the school board is endorsing religion by disclaiming the teaching of evolution in such a manner as to convey the message that evolution is a religious viewpoint that runs counter to other religious views. In the year 2000, a Minnesota school teacher, Rodney LeVake, argued that he had a right to teach evidence both for and against the theory of evolution. The school district considered the content of what he was teaching and concluded it did not match the curriculum which required the teaching of evolution. Case dismissed. Next slide, please. Slide number 8. Can you put a warning sticker on a biology textbook? All right. In Cobb County, Georgia, textbooks were required to attach this sticker. This textbook contains material on evolution. Evolution is a theory, not a fact, regarding the origin of living things. This material should be approached with an open mind, studied carefully, and critically considered. In 2005, the judge says, no good, this violates the Establishment Clause. 2005 was a bad year for the creationists. In Dover, Pennsylvania, the school board adopted an intelligent design policy. And in plain English, intelligent design is creationism with a few changes of vocabulary. A bunch of parents sued, and they said this policy violates the Establishment Clause. There was a 2-month trial in 2005, and Judge John Jones III issued a 139-page ruling in the Kitzmiller case. He ruled that the policy violated the Establishment Clause. He did it with gusto. He ripped it apart. It was a huge victory for the teaching of evolution. And I want to add as a side note, I used to work with an organization whose mission was to train judges on issues of science in the courtroom. How do you know the difference between science and junk science? We did an entire seminar, an entire conference on training judges on how to deal with issues of evolution and the other stuff. We got Judge Jones to come speak to our program shortly after the Kitzmiller case. And he said, you want to know what the moral of the story is? He said, I was appointed by President George W. Bush. I understand there are people who actually expected me to rule in favor of the intelligent design argument because that was being promoted by certain religious groups that are perceived as being supportive of President Bush. He said the moral of the story of this case is judicial independence. I took an oath. I tell you, when he finished, I wanted to go run out and salute the flag. It was wonderful. What happened in the appeal in the Kitzmiller case? It's a trick question. There was no appeal. Why? Because the school board that did all of that got voted out, and that was the end of that. In 2012, the state of Tennessee got back into the business of legislating about the teaching of evolution. Now you have to ask, what exactly could Tennessee legislate? Because the Supreme Court had told us by this point, you can't ban the teaching of evolution, you can't require balanced treatment. We know from other courts teachers had no right to teach creationism, and you couldn't substitute intelligent design for creationism. What could Tennessee possibly do? I'm going to take you through this law at a little bit of length because I don't want to characterize this. I want you to hear the words that they used put into the law. I've put it on the screen. Let's go to slide number 9. I'll put it on the screen so you can follow along. Slide 9. The law says, what happened to slide 9? That's the slide I have for 9. Wasn't the slide I had. Go ahead. Let's just see what, again? Okay. An important purpose of science education is to inform students about scientific evidence and to help students develop critical thinking skills necessary to becoming intelligent, productive, and scientifically informed citizens. The teaching of some scientific subjects, including but not limited to biological evolution, the chemical origins of life, global warming, and human cloning, can cause controversy, and some teachers may be unsure of the expectations concerning how they should present information on such subjects. Next. The schools shall endeavor to create an environment within public elementary and secondary schools that encourages students to explore scientific questions, learn about scientific evidence, develop critical thinking skills, and respond appropriately and respectfully to differences of opinion about controversial issues. The schools shall endeavor to assist teachers to find effective ways to present the science curriculum as it addresses scientific controversies. Toward this end, teachers shall be permitted to help students understand, analyze, critique, and review in an objective manner scientific strengths and scientific weaknesses of existing scientific theories covered in the course being taught. Next slide. The school shall not prohibit any teacher from helping students understand, analyze, critique, and review in an objective manner the scientific strengths and scientific weaknesses of existing scientific theories covered in the course being taught. This section only protects the teaching of scientific information, shall not be construed to promote any religious or non-religious doctrine, promote discrimination for or against any particular set of religious beliefs or non-beliefs, or to promote discrimination for or against religion or non-religion. This singling out of biological evolution and a few other controversial subjects is, of course, tantamount to putting a warning sticker on these subjects, like the warning sticker that was ruled unconstitutional in Selman. What else does this sound like? It sounds like Edward versus Aguilar, the balanced treatment case, because all of this stuff is the rationale behind the balanced treatment law. You got to do one and the other alongside each other, but it's without the mandate to actually teach creationism. As Justice Brennan said in the Edwards versus Aguilar case, the stated purpose behind the Balanced Treatment Act is academic freedom. But as the governor of Tennessee said about this law, nothing in this law changes anything about how the schools operate. So he said that, of course, when he vetoed the bill, right? Don't be ridiculous. He didn't veto the bill. He didn't sign it. He just, as an act of political courage, he did nothing, and that enabled it to go into law. Why did they do this? Why did they do this? I go back to Justice Brennan in the Edwards case. We need not be blind in this case to the legislature's preeminent religious purpose in enacting the statute. What's going on here? The state of Tennessee cannot give it up. They cannot accept that science should be taught as science. So if we take a breath, we'd say, well, at this point, from the perspective of the evolution issue, if you're on Team Scopes, you're feeling pretty good. But what about the larger canvas of church and state, religion and the law? Since the year 2017, it has been a steady stream of bad news for Team Scopes. Now, I had slide 12, but we may need... Okay, go ahead back. Okay. Trinity Lutheran. Again, I'm going to rifle through these cases. Any one of them would be interesting to discuss. I want you to get the sense of the trend here. Missouri's state constitution says can't use public funds for churches. Therefore, when Missouri had a program for funding the renovation of playgrounds to use a rubbery surface, like the one that's in the playground on the Upper West Side where my grandson used to go, right? We'll give funds to help schools renovate their playgrounds. But our state constitution says no public funds go to churches. Therefore, Trinity Lutheran Church cannot get one of these grants to renovate its playgrounds. U.S. Supreme Court said that the Missouri State Constitution violates the federal First Amendment free exercise of religion clause. It's discrimination against religion to deny these public funds to a religious group by a vote of 7-2. Now, 4 of the 7, including Justice Kagan and Justice Breyer, said it's just about playgrounds. And Justice Breyer said, helping them with the playground is a little bit like providing police and fire protection, which everyone agrees should be provided to all institutions, including religious institutions. The 2 in dissent were Justice Sotomayor and Justice Ginsburg. And Justice Sotomayor wrote, properly understood, this is a case about whether Missouri can decline to fund improvements to the facilities the church uses to practice and spread its religious views. That's Trinity Lutheran. Next, in 2020, Espinoza versus the Montana Department of Revenue. Montana had a tuition assistance program for parents to send children to private school. The Montana Constitution prohibited governmental aid to any school controlled in whole or in part by any church, sect, or denomination. That's the Establishment Clause principle. Supreme Court, by a vote of 5-4. This is discrimination against religious schools and the families whose children hope to attend them. It is impairing their free exercise of religion. 2021, Fulton versus Philadelphia. The city of Philadelphia contracts with private agencies to certify prospective foster parents. Catholic Social Services will not certify unmarried or same-sex married couples. Other agencies will. The city of Philadelphia says Catholic Social Services is violating the non-discrimination clause in our contract with them. Supreme Court, this violates Catholic Social Services' free exercise of religion rights. 2022, Carson versus Macon. Maine offered tuition assistance for parents who live in school districts that neither operate a secondary school nor contract with a school in another district. Maine limits that assistance to non-sectarian schools. The Supreme Court says that limitation violates the Free Exercise Clause. Kennedy versus Bremerton School District, 2022. This case got a lot of public attention. A public high school football coach was fired for leading a prayer at midfield after games. Supreme Court, the Free Exercise Clause protects a person engaged in personal religious observance from governmental reprisal. The Supreme Court has 3 religion cases under consideration this spring. Again, I can't discuss them with you in detail. I just want you to have a feel for the arguments as part of the overall direction of things. Let's go on to the next slide. Yes, thank you. Catholic Charities Bureau versus the Wisconsin Labor and Industry Review Commission. Employers must pay into a state unemployment insurance fund. There are exemptions from that requirement for organizations operating primarily for religious purposes. Catholic Charities had paid into this system for decades, identifying its work as charitable, educational, and rehabilitative rather than religious. In 2015, Catholic Charities demanded the exemption from the requirement to pay into the unemployment insurance fund. The Wisconsin Supreme Court said this charitable work was primarily secular, so employees who are doing the work deserve the protection of the unemployment insurance fund. In the Supreme Court, Catholic Charities is saying they're entitled to the religious exemption because our work is religiously motivated. And let me quickly add, I'm sure I'm doing a disservice to their argument, which of course has layers and some nuances to it, but that's, I think, the guts of it. Next case, Mahmoud v. Taylor. Montgomery County, Maryland, a suburb of the District of Columbia. The school district approved a handful of books for its language arts curriculum that included LGBTQ plus characters. Originally, parents who had religious objections could opt their children out. Then the school said that administering the opt-outs was too disruptive. The trial and the appellate court have ruled in the school district's favor, saying essentially simply introducing children to differing points of view does not violate anyone's free exercise of religion. In the Supreme Court, the parents are arguing, you allow opt-outs for other things, you have to allow us to opt out. I've listened to the oral argument of this case. The core issue, or one of them, is about the line between exposure to offensive materials and coercion. And there's also discussion about how administratively difficult it is for the school system to handle the opt-outs. Lastly, Oklahoma Statewide Charter School Board versus Drummond. How do you like that, Drummond? The issue is, can the state allow St. Isidore of Seville Catholic Virtual School to become the state's first religious public charter school? Americans United for Separation of Church and State and the ACLU and others sued, saying no. Oklahoma's Republican Attorney General also sued, saying such a school would violate the religious freedom of Oklahomans. The argument for the school is, if you deny us charter school status simply because we're religious, that's religious discrimination. Yesterday, I had the chance to listen to the first 15 minutes or so of the oral argument in the Supreme Court. Justice Sotomayor asked the lawyer for the school, could the school ban the teaching of evolution if it thought it was contrary to religious doctrine? Then all of my hopes were dashed when that question got lost in a maze of other questions and the lawyer was not put on the spot to actually answer it. At least there was no answer in the first 15 minutes that I've heard. Let's stop the share, please. Supreme Court cases are generally complicated. One cannot reach an informed conclusion without being familiar with the facts of these cases. How do these government programs actually operate? So I'm not comfortable talking about cases where I haven't read the briefs, which I haven't done except in the Mahmoud case. But there is an unmistakable pattern since the Trinity Lutheran case, the playground case. If we spend public money on non-religious things, refusing to spend public money on religious things is going to be regarded as discrimination based on religion and deemed to violate the free exercise of religion clause. If my religious belief compels me to treat you differently based on your sexual orientation, that's my free exercise of religion. One might ask, where are the limits to this? Well, if you can't see the limits, neither can I. In 1965, John Scopes wrote a piece entitled Reflections 40 Years After. He said, I'm sure that the Supreme Court, as it was then constituted, would have recognized that the Butler Act was an effort on the part of a religious group, the fundamentalists, to impose by law their religious beliefs on the rest of society. Our founding fathers, acquainted with the bloody religious wars in Europe, had written into the Constitution the right of religious freedom and had further provided, by means of the doctrine of the separation of church and state, that no religious group should control or unduly influence any arm of secular government. I believe that had we reached the Supreme Court, we would have been victorious on this issue. No descendant of Team Scopes will say the same of today's Supreme Court. So whatever happened to the Butler Act? The state of Tennessee repealed the Butler Act in 1967. Why did it repeal it? It had rejected earlier efforts at repeal. Well, 1 month earlier, in April 1967, in the town of Jacksboro, Tennessee, 80 miles from Dayton, there was a first-year science teacher, Gary Scott, who lost his job in part for allegedly violating the Butler Act. Scott said he'd only told students about the Butler Act and had not actually taught evolution. He was soon reinstated, but his lawsuit created legal expenses and bad publicity. Professor Randy Moore, he's the one who wrote the biography of Scopes. Randy Moore wrote elsewhere that the bad publicity and legal expense of dealing with Mr. Scott, that was what prompted repeal of the Butler Act. So what was the Scopes trial about? Different commentators, different comments. I'm moved by the analysis of the author Ray Ginger, whom you have heard me cite repeatedly. Ray Ginger says, it's not that simple. I want to read you a chunk of what he said. He said, no law moves a majority, and the minority excited about the Butler Act was very small. The great mischief done by Bryan and the fundamentalists was to raise the issue at all, to force people to choose between religion and science, or else to find some way to reconcile the two. He said even persons who had grown cool in their religious faith were likely to plunk for it, to approve it, the Butler Act, if put to the test. Probably God did exist. Maybe there was to be a last judgment, an eternal state of rewards and punishments. At least it could do no harm to vote that way. The childhood training of most Tennesseans, the full thrust of their upbringing, their locality to the ways of their fathers were in that direction. They had no similar loyalty to reason and science, which still are bloodless abstractions to the great majority of mankind. Brian used the popular education of the parents to undermine and negate the education of the children. Remember reporter Paul Anderson? He's the one who called Darrow's cross-examination of Brian an event in the intellectual history of the world. I say that that cross-examination and the trial generally were about not only the separation of church and state, but ultimately about our relationships with our co-inhabitants on this earth. H.L. Mencken dubbed it the monkey trial, thereby forever contributing to the distortion of Darwinian theory. But it was Brian and his followers who were the ones to make fun of our supposed connections to the other species. You remember Brian belittling the evolutionary tree that I showed you in Hunter's Civic Biology, with its 500,000 species of animals at the time, the insects, mollusks, and protozoa, and Brian's jab at descending not even from American monkeys. As I trust has become readily apparent to all of you throughout this course, I am no scholar of religious texts, but I think Scripture takes us entirely in the other direction. For guidance and inspiration along these lines, I went to the writings of another friend of mine, the late Everett Gendler of Great Barrington. Everett was a rabbi, and the title of his collected writings, Judaism for Universalists, tells you much of what you would need to know about his view of Judaism and the world. Everett wrote the following. He was not writing specifically about the Scopes trial, but you sure could have fooled me. He wrote, Charles Darwin was not the first human being to posit a close relationship between human beings and other animals. He may have put this particular notion to new theoretical use, and he may have made our sense of kinship with other animals function differently in this particular age from the way it did in the centuries preceding. But the fact is that man's sense of relatedness to other living creatures is a very ancient inheritance of the human species. Various psalms express clearly the psalmist's close identification not only with human life, but also with the entire life of the universe, even as it expresses itself in the lives of the beasts of the field, the monsters of the deep, and the birds of the air. Granted, humans surpass the capacities of the animals in some respects. Genesis is explicit about this. But the basic relatedness is not lost sight of, even with the awareness of difference. What did the Scopes trial have to do with our relationships with our fellow human beings? And specifically, to the most fraught aspect of those relationships, certainly in American history, namely, what did it have to do with race? In 1925, a piece appeared in the magazine of the NAACP, The Crisis. It was written by a William Pickens, then the field secretary of the NAACP. Pickens was an educator and syndicated columnist. He published his own autobiography, an extraordinary book. He was the first black Phi Beta Kappa graduate of Yale University. I've posted this next piece on the Padlet. I want to give you the first and last paragraphs. In the first paragraph I'll read, Pickens uses the term Brobdingnagian from Gulliver's Travels, a way of referring to being on the scale of giants. Pickens began, 100% Americans are now endeavoring to persuade hilarious and sarcastic Europe that Dayton, Tennessee is a huge joke and very exceptional. And in proof of all this, the learned American press is emitting huge guffaws and peals of Brobdingnagian laughter combined with streaming tears. But few are deceived. even of those who joke and slap each other on the back. The truth is, and we know it, Dayton, Tennessee is America, a great, ignorant, simple-minded land, curiously compounded of brutality, bigotry, religious faith, and demagoguery, and capable not simply of mistakes, but of persecution, lynching, murder, and idiotic blundering, as well as charity, missions, love, and hope. Pickens concluded, "The folk who leave white Tennessee in blank and ridiculous ignorance of what science has taught the world since 1859, origin of the species, are the same ones who would leave black Tennessee and black America with just as little education as is consistent with fairly efficient labor and reasonable contentment. Those are the folk who rave over the 18th Amendment, prohibition, and are dumb over the 15th, prohibiting denial of the right to vote based on race. Those are the folk who permit lynching and make bastardy legal in order to render their race pure. But Dayton, Tennessee is no laughing matter. It is menace and warning. It is a challenge to religion, science, and democracy." That piece and the next one underscore it did not take 100 years of hindsight to see what this trial meant to the value of pluralism. This next piece was published on July 21st, 1925, the last day of the trial. It was written by a Congregationalist minister named Rollin Lind Hart. It was published in The Nation. Hart, I'm told, was an early 20th century journalist as well as minister. His reporting and views on fundamentalism were known nationally and were mentioned in, among other places, Time magazine. I've posted this piece. I'm going to quote from it at length because I think America should hear it. He wrote, "The separation of church and state is put on trial in Tennessee. The Fundamentalist Party, engaged just now at Dayton in defending an ancient Chaldean creation myth, which was copied into the first chapter of Genesis 2,300 years ago, the Fundamentalist Party is by far the most interesting factor in American politics. It does not call itself a party or believe itself to be one. It is not commonly recognized as such. Its leaders neither hold nor seek public office. Nominally and to outward appearance, the Fundamentalist Party is a religious organization, and that alone. In effect, however, it is much more. Without troubling to name candidates for office, it aims to control the men who are already in office by coercing legislatures and ultimately Congress, and thus securing what all political parties strive to secure, namely laws embodying its own convictions. According to Mr. Bryan, the Fundamentalist Party will not be satisfied with writing a defense of the 2,300-year-old Chaldean creation myth into the criminal code of state after state. It must be written into the federal Constitution itself." Hart continues, "But evolution is only superficially the issue at Dayton. At bottom, the issue is a vastly older and vastly more important question, the question as to whether the separation of church and state shall be maintained. To be sure, there is no mention of this at Dayton. The fundamentalists are not saying even among themselves there should be a Protestant state church in America, nor are they saying even among themselves theocracy is the ideal system of government. No such monstrous ambitions are consciously entertained by fundamentalists, but the significance of fundamentalism lies not in what it is consciously, but in what it is unconsciously. Unconsciously, it puts the church above the state." Hart says, "Today it seems ridiculous to hint that America may, in course of time, change from a democracy to a theocracy, but only a short while ago it would have seemed as ridiculous to predict that a former Secretary of State, Bryan, holding honorary degrees from several institutions of learning, would one day be defending a 2,300-year-old Chaldean creation myth, and in so doing, advocate the principles of theocratic despotism. We clearly perceive and resent the apparently isolated onslaughts of fundamentalism upon our liberties, but we do not recognize as clearly or resentfully its underlying policy. So we combat fundamentalism not in its essential character, but in its manifestations. We have an association against the Prohibition Amendment to fight fundamentalism's control in matters of personal habit. We have a Science League in America to fight its monkey bills. But we have as yet failed to combat its underlying policy by founding a league to maintain the separation of church and state. Americans United for Separation of Church and State came about 25 years later. Hart continues, through methods purely educational, such a league might do quite a little toward Christianizing the fundamentalists. Gently and with suitably adroit diplomacy, it could remind them that Jesus of Nazareth, to whose precepts and example they now attach but slight importance, never prosecuted his fellow men for seeking enjoyments different from his own, and never sought to obtain from the Roman government the power to do so. He conceived of religion as a persuasive, not a coercive force. He believed in the separation of church and state. Which brings us back to William Jennings Bryan and his wife Mary and Dayton, Tennessee. Let's switch slides, and we're going to go forward to the slides that have the text of that discussion, because those slides are at the end. Okay. Let's look at what Mrs. Bryan wrote. She said he was trying to do three things. Let's examine them. First, she said he was trying to establish the right of taxpayers to control what is taught. But under our Constitution, that right is not unfettered. Taxpayers do not get to decide that we will teach the superiority of one religion to another, or that we will prefer religion to non-religion. Second, she made reference to his efforts about distinguishing between teaching evolution as a theory rather than a fact. But this miscomprehends what a theory is in science. The scientists can tell you it is not a guess or a hunch. Scientists know that a scientific theory is an explanation of the natural world that has been repeatedly tested and verified using the scientific method. Third, she points out one of his objectives was that a teacher proven guilty should be given the opportunity to resign. Well, that's a nice way of saying quit or be fired, which is another way of saying you're fired. Let's continue to the next slide. But let's get to the bigger picture. I say to Mr. Bryan, I, like Darrow and Malone, would have made common cause with you on many of the issues for which you fought. Women's suffrage, worker rights, etc. We share certain values. So it's from that set of shared values that I say to you, Mr. Bryan, when Mrs. Bryan warned that no religious zeal should become intolerance, and she asked you, will you be able to keep to this narrow path? And you responded, I think I can. I say in all candor, from the perspective of 2025, you did not. Perhaps not out of intent, but we are all responsible for the consequences of our conduct and our rhetoric. Today, we live with the consequences of your conduct and rhetoric. We live with the science deniers, with the influence of religious fundamentalists that infect our politics with intolerance, with the resistance to minority rights because of their unpopularity with the will of the majority. But I go a step further. You asked your wife, I have not made that mistake yet, have I? And she said, you are all right so far. With respect, She was wrong, and so were you. You had already made that mistake. The trial transcript tells me so. I heard in the transcript Tom Stewart attack Clarence Darrow as an agnostic, using the term as an epithet. I heard members of the prosecution team refer to the places where defense counsel came from as heathen and not God-fearing. I heard you deride other religions as inferior, as if that were a basis for making education policy in the state of Tennessee. And in your memoir, I read where you wrote that you were born a member of the greatest of all the races, the Caucasian race. Perhaps you personally would not have said that there were fine people on both sides when the white supremacists marched in Charlottesville in 2017, chanting, among other things, "Jews will not replace us." But there is a line, dotted perhaps, from your rhetoric to theirs. No, you did not control your followers in the years to come, in part because you did not control your followers or yourself in 1925. Let's stop the share. 2 weeks before this class began, I spent 3 days in Dayton, Tennessee. I wanted to see the courthouse. I wanted to stand in the courtroom and be where they had been. And yes, I had dinner in a place called the Monkey Town Brewery. Like my ancestors on Team Scopes, I was treated with warmth, graciousness, and friendship. I went to Dayton because I wanted to get the answer to one question. What does Dayton say is the moral of the Scopes trial story? Now, no town or community is a monolith, but I heard enough and asked enough questions to be confident that what I'm about to say is fair and accurate. If you ask Dayton, Tennessee, what the moral of the Scopes trial is, their answer is quite likely to be, we were mistreated by Inherit the Wind. Dayton was not the fundamentalist hick town Hillsborough, and William Jennings Bryan was not the buffoon Matthew Harrison Brady. If you go on to ask, what do you think about having banned the teaching of evolution? The answer would be some version of, that's a hard question. Well, here's a story that's not a hard one. It's about a public elementary school that established a Bible education ministry for its kindergarten through 5th grade students. The program was operated through a local Christian college. Those college students volunteered to help these public school students become exposed to the Bible. This was not Bible as literature, not Bible as history. This was Bible as religious truth. The parents of 2 elementary school students filed a lawsuit. A local principal said, if I'd known they were filing a lawsuit, I would have tried to alert them. Look, do you want to cause your family trouble? This is a rural conservative place and very emotional about religion. Attack religion and crusades begin. But you need to follow your own conscience. The trial judge said, this is not a close case. In his decision, the trial judge noted that the lawyers for the school argued that since this county is a place where they respect the Bible, it ought to be at liberty to teach the tenets of the Bible in its public schools as truth. The judge, this argument reflects a misunderstanding of the Constitution of the United States. It's probably true that the citizens of this county who are of the Christian faith are in the majority. This, however, does not give them license to teach their religion in the public schools. The Constitution in this area and others protects persons who happen to be in the minority. We all, the majority and the minority, live in the same nation. The Constitution protects each one of us, including those of us who may not have the same religious views as the school board. That decision was written in 2002 by a federal judge who was appointed by President Reagan. Most interesting, the public elementary school in the story was in Ray County, Tennessee, the home of Dayton, Tennessee. The names of the parents who filed the lawsuit, don't be silly, John Doe and Mary Roe. They shielded their names from the public. What's the moral of this story? The moral of this story is that with all due respect, the people of Ray County do not get the moral of the story of the Scopes trial. What was said in a fictional account of the trial, we can discuss that. We can, as we have, and we can debate it. And reasonable people can disagree about how fiction ought to depict real events. But the real moral of the story is in what was actually said and actually done by actual people at the actual trial. Seeing this 2002 court case is troubling enough. Hearing the same sentiments repeated in 2025, this is a county where we respect the Bible, therefore, is deeply disturbing. This kind of fundamentalism is antithetical to pluralism, to a society that tolerates, indeed encourages, diversity of religious and non-religious points of view. So 100 years after the trial, I have a fantasy. The fantasy involves talking to William Jennings Bryan, because I have a request for Mr. Bryan. So in my fantasy, I say to him, Mr. Bryan, you prepared a closing argument that you never got to deliver in court. It was published after you died. You said something in that argument that speaks to today. You said in that closing argument, Tennessee does not undervalue the service rendered by science. The Department of Medicine also has an unlimited field for invaluable service. Typhoid and yellow fever are not feared as they once were. Diphtheria and pneumonia have been robbed of some of their terrors, and a high place on the scroll of fame still awaits the discoverer of remedies for arthritis, cancer, tuberculosis, and other dread diseases to which mankind is heir. Mr. Bryan, you paid greater homage to science than does our current Secretary of Health and Human Services. Mr. Bryan, we need your help. We need you to speak out. We need you to talk plainly to the American people about what freedom means and what it does not mean. That freedom is not denying the difference between FDA-approved vaccines and snake oil. Freedom is not doing whatever we want, public health be damned. We need you to tell your followers, we won in 1925, and we were wrong. Freedom is not using public money to support religious institutions and their religious missions. It's not removing books from libraries and schools because their ideas may not be our ideas. Freedom is not banning the teaching of what makes us uncomfortable. Like I said, it's a fantasy. As I begin to wrap up, I have some thank yous. First of all, to those of you here in the Indigo Room and those of you on Zoom, thank you for joining me in this 6-week exploration. I said in my opening remarks in the first week that I fell under the spell of this trial when I was 11 years old or so, watching Inherit the Wind and thinking, this is disappointing. I'm going to be a lawyer, but they've already tried the most fascinating case ever. Through this course, you've enabled me, in a manner of speaking, to try the case again. I want to thank our staff at the Mahawi, to Thomas Randall and Lucas Pavelski, who's here at the beginning each session. You guys made sure all the systems were go every week. I want to thank an OLLI volunteer named Darrell Brook, who responded to my plea for someone to whip these PowerPoint slides into shape so they didn't look like a lawyer had prepared them. I want to thank, as always, OLLI and its leader, Carol Allman Morton, for supporting classes and programs that interest me and allow me to present them to the community, in particular to the wonderful Judith Weiner of the staff of OLLI, who became my new best friend by volunteering, in a manner of speaking, to relieve me of the task of operating the PowerPoint. Judith came to the US from Australia when she was 24 years old. So there are some parts of American culture that she missed. But I'm gratified to know that after 6 sessions of 90 minutes with us, Judith now knows about to tell the truth. I want to offer a different and special thanks to someone I hope I can call my friend, to Tom Davis, a leader in Dayton, Tennessee of the Ray County Preservation Foundation and actively involved in all things Scopes. Tom, if you ever have occasion to see the recording of this, thank you for all you did to make my trip to Dayton all that it was. Thank you for showing me Tommy Brewer's house. And thank you for allowing me to engage with you on these issues in a deeply personal way. I have been consumed by this course, which means a lot of people within the sound of my voice have had to listen to this stuff for the last 8 to 10 months. 3 of them merit special attention. First, my friend Howard Jaffe, for helping me understand better at least one rabbinic perspective on biblical interpretation. To my friend John Nelson, the pastor at the Congregationalist Church in Salisbury, for helping me better understand at least one Christian perspective. And finally, if I ever had been unable to appear for one of these class sessions, I'm confident that my wife, Wendy Jennis, could have stepped in seamlessly. She has heard all of this repeatedly for a long time, and all with interest and support and apparent good spirit. I'm trying to think of anything meaningful I have done in the last 37 years where Wendy was not my partner. I can't. What about the characters in the trial? I am indebted to Arthur Garfield Hayes, Dudley Field Malone, John Neal. They all stepped up. What about Darrow? What a career, warts and all. Language was the currency of the Scopes trial, and so much of it came from Darrow. His eloquence so moved the playwrights and the screenwriters, they used his words in their scripts. And when they had Henry Drummond say in Inherit the Wind, an idea is a greater monument than a cathedral, it's no stretch to think that Darrow himself could have said that. His use of language moves me in part because of the lens through which he saw life. I cannot resist giving you one more quote. Darrow said, "I have gotten into trouble for being misunderstood. I would have gotten into a lot more trouble if I had been understood." If Darrow were here today, I'm sure he would update his earlier remarks. If today you can take a thing like evolution, or science, or gender studies, or the history of racism in America, and make it a crime to teach it in the public school, tomorrow you can make it a crime to teach it in the private schools, and the next year you can make it a crime to teach it in the hustings, or in the church, or in the Osher Lifelong Learning Institute. And at the next session you may ban books and newspapers, and websites and podcasts. Soon you may set Catholic against Protestant, and Protestant against Protestant, and against Muslims and Hindus and Jews and atheists and agnostics and all the rest of us, and try to foist your own religion upon the minds of men and women and the trans and the non-binary and the gender fluid. If you can do one, you can do the others. Ignorance and fanaticism is ever busy and needs feeding. 100 years later, those words sing to me. 100 years later, I think our antennae are even better attuned to the difference between inclusion and exclusion, between tolerance and intolerance, between love and that other thing. Yes, it feels today like ignorance and fanaticism is busier than ever and is well fed. That's one of the principal reasons I've taught this class. I find inspiration in many of the characters, real and fictional, associated with the trial. They give me some faith that ignorance and fanaticism, although busier than ever, will not necessarily win. So I remain in awe of Darrow. But after living with this trial now for several years, I'm left with a different and an even more profound appreciation of someone else. I mean, Darrow was a lawyer. He signed up for these kinds of battles. John Scopes was 24 years old. He was a high school football coach who did some teaching. He'd been in Dayton for 9 months. The guy's playing on the tennis court when they pull him into Robinson's drugstore, and they put the question to him, "How about it, Scopes?" And he didn't say, "Let me sleep on it. Let me consult with my advisors. Let me think about how it will look on my resume." He said, "Yes." In that moment, he wrote the first line of his obituary, and he wrote himself into history, the right side of history. There are elements of a Hitchcock movie to this. This is an ordinary person caught up in an extraordinary situation. I think a lot about that phenomenon. Pivotal moments in one's life when a person can rise to the occasion or shrink from it. Moments that we couldn't have seen coming. We will all have moments that call upon the Darrow in us when we're asked to draw upon our professions, our actual work, our personal experience. But then there are the moments that come out of nowhere, where all we have are our instincts and our values. For those who see this differently from the way I do, well, that's pluralism for you. And I look forward the rest of today and on into the future in engaging in dialogue wherever the opportunity presents itself. I trust, I hope, I have avoided giving offense during the course. If I have failed in that effort, I apologize. For those of you who share my sentiments, what can we do? I say we look to the example of John Scopes. He knew when his moment presented itself, he saw an opportunity, he took it. In fact, he helped create that opportunity, and he did so with uncanny grace and intelligence. This is our challenge, to know our opportunity when we see it, to help create those opportunities. Yes, I find that teaching and that inspiration in the trial of John T. Scopes. I hope each of you has found something in that trial for you. Thank you. Thank you. Before we dig into what I hope will be some robust Q&A and discussion, let me remind everyone, next Monday night, 7 o'clock, my Zoom interview with Ed Larson, author of Summer for the Gods. I have already promised him the best informed audience ever for one of his talks. So take the gloves off, don't hold back. I'm looking forward to it and looking forward to having many of you join us.
How do you find that?
It's on the OLLI website.
Right. You go to the OLLI website, and it's there as part of the Distinguished Speaker Series with all the appropriate links for registering. Have we got some chats?
Brian asked about half an hour ago, is it fair to say that the Big Bang Theory supports creationism? Something was created out of nothing about 13 billion years ago.
So this business about original, how did it all begin? I mean, I suppose the astrophysicists and others, have some, there's a scientific realm for exploring how far back can you go and where did matter come from and all of that stuff, which of course, if we're talking about things beyond the realm of what I should be talking about in public, that should be very high on the list. But at a certain point, how did it all begin, veers into the beyond the realm of the physical world into the spiritual and other kinds of questions. And that's a distinction, we're trying to maintain. Naomi.
In the modern era, I'm wondering how you or Clarence Darrow would comment on the Hobby Lobby case.
Sure. Naomi's asking how any Team Scopes would comment on the Hobby Lobby case. The Hobby Lobby case was before Trinity Lutheran, and I may be weak on the particulars, but this was about an employer, I believe it was denying certain benefits based on the religious preference of the employer. Is there more you want to add to that?
It brought the whole question of how religion deals with abortion rights,
Sorry.
as a religious issue.
Yeah, I mean, that was one of the cases where employers are asserting we have religious beliefs that stand behind this organization, and Team Scopes says once we get into the realm of employment that is publicly regulated, namely people have rights not to be discriminated against, they have all kinds of rights to be treated similarly in similar situations, to begin to impose religious dictates on that outside of a religious setting. The Establishment Clause gives all kinds of protections to places of worship and private religious schools to what they can do, and they are shielded from many obligations that non-religious schools are subject to. That's done in the name of we don't want the government getting entangled in decisions that religious institutions make. Where life gets complicated is where we have an employer who says, well, but my company, I promote religious values in the operation of the company. And to my way of thinking, that gets back to the distinction I tried to make a few minutes ago, which is the difference between a conduct which is religiously motivated. I'm motivated to eradicate poverty based on my religious beliefs, versus taking religious doctrine and making it the law.
In one of the earlier slides you put up, you had in quotes the science of evolution and I think the science of creationism. And I was wondering why in the first trial they didn't go right to how you define science. And that would have been like, to me, encapsulated the whole thing, because obviously religion isn't science. And you didn't mention that with the supernatural thing, but...
Yeah, so the question is why at the Scopes trial didn't they do more to kind of sharpen the distinction between science and religion? This may be hard for you to understand, but we didn't actually go through every line of testimony in the trial. But I am thinking of a follow-up course, the Scopes trial, in depth next year. Whatever happened to Tommy Brewer after he pulled the names out of the hat? The answer is, first of all, remember, the judge ruled out the science testimony from the science experts. When you read the affidavits that were prepared by the science experts, and I gave you a piece of one of them a couple of weeks ago by that guy Kirtley Mather, I think the geologist, he very much went into this is what science is, and this is what it isn't, and this is what religion is, and this is what it isn't. So the words may not have been spoken out loud in the courtroom. That's largely because the judge said, that's not what this trial is about. When, of course, Team Scopes thought that was what the trial was about. That's what left Darrow with the only option being put Brian on the stand and let's get him to talk about the Bible.
Kid asks, it strikes me that if these issues hadn't been in a trial, Darrow and Brian might have agreed on many points. By being in a trial, it became very black and white. How can we address these religious issues outside the courts where it becomes too black and white?
Well, Darrow and Brian did agree on, I'm not sure, many things, some things in the political realm, to be sure. He supported him for president twice. And, the workers' rights, the women's suffrage, that stuff, they agreed with each other. When we get into the realm of this religion, the role of religion in public life, I don't think there was much that the two of them would have agreed on. I think that's the realm where they had been at odds for years, and had been public about being at odds with each other. You may recall Darrow publishing a list of questions in one of the Chicago papers that he wanted Brian to respond to, and Brian saying, I'll answer his questions when he answers mine. So I think there was not going to be any agreement about anything significant when it came to the realm of the role of religion in public life. And that stems in part from the fundamental disagreement between them about Brian believing he was a majoritarian. So you hear his arguments about, if people want this stuff taught in schools, then it ought to be taught in schools. And if they don't want that other stuff taught in schools, that's the right of parents to decide that. That's majority rule. And of course, Darrow and the ACLU were all about minority rights that may be unpopular with the majority. Their view, the Team Scopes view, is that's what the Constitution is there for.
KJK writes, please explain why public schools can have a prayer at graduation. Also, why can towns hang Christmas/Hanukkah decorations? What do these allowances say to an atheist or anyone of another religious belief? Why are only monotheistic religions embraced by these events?
You all heard the question, right? You tell me. The answer is most of what the questioner alluded to isn't even up for grabs anymore. That's how bad, in the view of Team Scopes, the state of the law is on the so-called separation of church and state. For years, those of us making these arguments have been on the losing side or having to play defense against what we regard as further encroachments on the Establishment Clause. Remember, establishment of religion, free exercise of religion, there's a built-in tension, to be sure. But the balancing act that has been struck in the past is now ancient history. And the free exercise of religion, I believe this is my religion, therefore you should give me public money in pursuit of that. Therefore, I should be free not to have to deal with people who are in protected categories that offend me, like LGBTQ plus stuff. So implicit in the question is, some of us deeply believe that the law has gone in a bad direction, and there is no foreseeable scenario where it changes anytime soon. We are fighting to limit the defeats. Let me give you an example, because I'll overcome my reluctance to talk about myself. In 2018, I tried a case for Americans United for separation of church and state. It was before I moved up here. They had a case in the Commonwealth of Massachusetts. It was just a coincidence that they asked me about a Massachusetts situation. We have the Community Preservation Act. And the Community Preservation Act creates public funds through a surcharge on real estate taxes, public funds that get used for housing, open space and recreation, and historic preservation. And each town that adopts the program has a community preservation committee. Great Barrington has one. And so in Massachusetts, who do you think loves the Community Preservation Act for its funds that go to historic preservation? The churches many of the churches of the Commonwealth of Massachusetts, because many of them can accurately lay claim to being historic buildings. So the Massachusetts State Constitution has something referred to as the Anti-Aid Amendment that said no public funds shall be used to aid a church or similar entity. So some members of Americans United in Massachusetts said, let's see what we can do about stopping the use of public funds to go to these churches because they're historic churches. So AU asked me if I would take that case. My first reaction was, here in Great Barrington, we have these two gorgeous churches, right? And I thought, what's so terrible? If Great Barrington decides to give money to lots of historic buildings, they give some money to the historic churches because those are beautiful buildings. And the next morning I woke up and I said, you know, if I want to give money to those churches, I can give my own money. But public funds to aid a house of worship, no good. So I signed on for the case. It was fascinating. Try to talk to people. Are you willing to be a plaintiff to sign on to the case? Oh yeah, I know. I agree with what you're doing, but you know, the town of Acton wanted to give $100,000 to a church in Acton because they wanted to restore stained glass windows with overt religious content. $50,000 for that. $50,000 for we're going to do a master plan, and then we're going to come back and tell you what else we need more money for. And the letter to the Community Preservation Committee says, as you know, mainstream churches are having a hard time financially. Oh, so now we're going to decide what's a mainstream church and what's not a mainstream church. Okay, so we need money to do this. So we go around trying to line up plaintiffs. You need people who say, I live here and I'm opposed to this. And people would say, yeah, I agree with you, but you know, my daughter just opened a medical practice in town and it would be pretty unpopular to take on the church. So I said, no. Right? One after another after another. When you look at the history of the Anti-Aid Amendment, what they said was, we need this amendment because nobody wants to stand up in the public square and oppose a church. Then we got letters on behalf of the church when they applied for the funds. We are the whatever club in town, and this church is a wonderful citizen of the community because they let us have our meetings there. I said, what about the religious groups that have a religious principle, say, of not having men and women in the same room together? So those places can't host. Now we're going to do this based on what churches are popular in town? It was fascinating. We took that case to the Massachusetts Supreme Judicial Court and we won. Supreme Judicial Court said, no giving money to the church for the stained glass windows, that's ridiculous. On the other piece, they said, oh, go back, have a trial, let's see what the money's going to be used for. The church said, we've had enough of this. They withdrew the application. That was the end of the case. I guarantee you, all over Massachusetts, community preservation committees are giving public funds to churches today. Why? Because if we brought that lawsuit today, the U.S. Supreme Court would say the Massachusetts anti-aid provision discriminates against religious groups. We can't bring that lawsuit, right? We won the battle, we've lost the war. That's when I say we're playing defense, we're trying to cut our losses when you do this kind of work because the Supreme Court is treating these issues the way that it is. Anything more?
A comment that I'm not sure is appropriate.
Okay. Anything else from the assembled? Yes.
This may seem minuscule, but when I watched the Inherit the Wind, and Brian was on the stand being questioned, he was talking about the creation and down to the time of day that it happened and so forth. Was that actually part of his testimony?
Yes. Yes.
And did people actually believe it?
I
mean, this is just, I was flabbergasted that people would actually believe that, much less that he would make that statement.
What do I know?
Okay.
Yeah, Ron.
Did and still do in my region of the country. I'm a refugee from the Ozarks.
Ron, speak up so people can hear.
Did and still do in my part of the country. And I'm a refugee from the Ozarks. And it's still like it.
You may recall I said something in that lecture that Ray Ginger commented in his book that when he said something about 9 a.m., somebody in the audience said something about Eastern Standard Time. It's not in the trial transcript, but then it, it shows up in the play and the movie.
Yeah.
So,
Thank you.
Steve.
There are two very closely related concepts. One is the creation of life, and the other is the evolution of life. And congratulations for getting to the richness of this divide through your presentation. Thank you.
Well, if you were trying to insult me, you're going to have to try harder, Stephen. I deeply appreciate it. Deeply appreciate it.
The inherent wind, I looked at something on Wikipedia for its more or less value, but I want to just read this to you. It says, according to Lawrence, the playwright, we use the teaching of evolution as a parable, a metaphor for any kind of mind control. It's not about science versus religion. It's about the right to think. I disagree with that. This is the playwright. But I wonder what you think of Lawrence's observation about his writing about the inherent belief.
Yeah, so the question is about what Jerome Lawrence, the playwright, said about what they were trying to accomplish with the play. And it gets back to where they said they wanted to write about McCarthyism. They wanted to write about this was, a constraint upon intellect and freedom of thought and inquiry. And you may recall I quoted from the guy who runs, or at the time ran, the Institute of Theater Studies at Ohio State, the Lawrence and Lee Institute, where he said, these guys used the Scopes trial in part because the issue of creationism versus evolution was settled. Right? So nobody would think that this was about that battle. It was no longer a battle. So, okay, they got that one wrong, which is why we're dealing with a world where it's perfectly understandable to say, well, yeah, Inherit to Win is about that because we still have that debate, that fight going on around us. So, but I understand Lawrence's point. Even though they missed their bet on it being a settled issue, sure, freedom of thought, that's what they wanted to talk about. I think they did. And it gets back to, that piece by one of those authors about the most interesting character in the play is the made-up character of Kate's girlfriend, who said, I'm not sure how I think about this, but said, wow, she's the one person who actually changes from the beginning to the end. She's the person that Lawrence and Lee were appealing to, because it's one thing to preach to the choir, but to change somebody's heart and mind, that's pretty good.
I could just quickly respond to that. I thought Reverend Brown in the movie was an interesting character, and I was astonished. Your description was the reason he was portrayed as well as he was because of censors. I assumed that was something to have a sort of even-handed treatment of people on both sides of the question. And despite all of my reservations about, I think one of the things that I resist is that many proselytizing is part of many organized religions. And I think it's not too hard to understand how proselytizing can then make its way into making law, which is not adequately important. I also think there's a way to be sympathetic to faith, and I thought that his portrayal about somebody who was truly emotionally distraught and how it was affecting his faith was a very interesting and sympathetic portrayal of that character.
Right. I take that point, and I agree with you. We saw him shaken, right? And it actually puts Brian, in a favorable light to say, our zeal can overwhelm us. We don't see him as a changed character in the sense of acknowledging what he had done. Who knows what the sequel would have shown. But part of your comment gets to why I'm so moved by the commentary of the modernist Christian clergy at the time. Because never mind Mrs. Bryan saying, you think you can control your people, although implicit in that is her recognition that there is a line. I think they didn't understand that even they had already crossed it. But a guy like Roland Lynn Hart, for him to say what he said about we need an Americans United for separation of church and state to teach the fundamentalists something about Christianity, listen, I'm not a Christian. I'm respectful when I start talking about other people's faith, but to quote him, that moves me. Anyway, We're at our appointed time. Let's let Roland Lindhart have the last word. We could do worse than that. Thanks again, everybody. Really appreciate it.